first, let me introduce myself. Hello, my name is Betty Esther, and I am the president of the Citizens Network of Protection. And we have Elizabeth Mello, who is the vice president of the Citizen Network of Protection, and we have our volunteer IT person, Patrick, who is online, and I need to kind of bring back online the other guest speaker for the night, Miss Ward, and that's Larry Redmond. So let me call him and tell him to log back in. So the other people that have signed in, would you mind introducing yourself and so.
So Betty, go ahead, Darlene.
Oh, thank you. Darlene Cannon, Second Ward board member. And I'm very interested in hearing about what we're going to be discussing tonight, since it was postponed several times. So, yes.
Thank you. And I'm going to ask Elliot to unmute at this point to introduce himself.
Okay.
Elliot, would you like to unmute and introduce yourself? Okay, maybe he will later. So Betty, who else did you want to introduce themselves?
I
You
guess-
introduced Patrick.
Yes, I
And-
did, but if Patrick wanted
Tricia.
to introduce himself and to say something.
Hello,
Hello,
what do you
Elliot.
want me to say?
Just to introduce yourself, please. We're just introducing ourselves at the start of this Citizens Network of Protection meeting. So Elliot, would you like to do that?
Say that again, please.
We're introducing ourselves at the start of this.
Oh, I'll do
Citizens
that. Yeah, I
Network
was
of
just
Protection.
handling a quick call. All right, yes, I'm Elliot Sation, formerly active with a group called Reclaim Evanston, longtime resident of Ward 9, and obviously have an interest in the issues that the Citizens Network of Protection has been promoting. And I'm long retired and not doing a whole lot of active, canvassing and politicking these
Thank you so
days.
much, Elliot.
How's
That's
that?
great. So then we have Patrick and Tricia. Would you like to unmute and introduce yourselves, please?
Hi, I'm Tricia Connolly, and I live in the Second Ward. And I'm somewhat active in the community, and I'm very interested in hearing more in regard to tonight's presentation. Thank you.
Great, thank you. And Patrick?
Hi, I'm Patrick Cosgrove. I previously worked in Evanston, and was introduced to the Citizen. But I also I do video production, freelance, and so I got involved to help the Citizens Network of Protection with all types of media stuff. And again, I'm very interested to hear the talk tonight, so I am excited for that.
Great, thank you, Patrick. And Betty already introduced me. I'm Elizabeth Meadows, Vice President of CNP. I live in the 4th Ward here in Evanston. So I've been active with Citizens Network of Protection, I think about 5 or 6 years now. So thank you, everyone. So back to you, Betty.
Okay, yes. So we have the Citizens Network Protection has been around since 2008. We officially became a non-for-profit organization in 2019 when we went through the big application for IRS and then the one for the state. And we said, okay, you fill them out and you submit it. And then they said, well, you have to pay for this. And I'm like, so we're just being a non-for-profit. So why are we having to pay you $500 to do this application? And then they tell you that, okay, you are 1,405 on the list as to where your application is. So the first thing you want to think about that comes to your mind, I don't know whether anyone else thought about it, and you saw all of these people that here in the United States that is trying to be non-for-profit, and they have to pay $500. Then what is the government saying that they don't have enough money? Because if you start multiplying, you start having, whoa, way too many. And it was just mean. So anyway, they was nice enough to go ahead, take out the $500, look at the paper and process it. So so in 2019, we officially became a non-for-profit and we completed working with it in 2021. We kind of finished doing our proposal for the civilian police oversight board. So we have completed that process, and that from that we will be having, we have had some meetings in the community to discuss the proposal and stuff. So we will go out and do more community involvement to get their feedback on the proposal. But basically CNP does educational event like this one where we let the people know what each department, like with the state, county, and local government does that is connected with the police department and the citizen have to be going through. So this is one of them that we have tonight. Did Larry sign in? Because Larry Redmond is going to be our second speaker. And I don't know, you might have, do you go to court with cases? Ms. Ward,
I'm
I-
sorry, do I go to court with what?
I see that you are the supervisor of the felony review unit. So do you ever go to court?
Yes, I have several homicide cases that I'm still following from when I was in the trial division. I've been in the state's attorney's office since I got out of law school, so for 25 years. So I've been through the child support division. I went through the Juvenile Justice Bureau, which includes the child protection side, which is abuse and neglect. And then I also was in delinquency. I went through the felony trial division at 26th in California, where I tried hundreds and hundreds of bench trials, including 93 jury trials, approximately 80 murder trials, and then before becoming a supervisor in the
Oh,
felony review unit.
okay, so you have lots of knowledge of the state's attorney office and stuff. So a good person. When we asked for a person from the state's attorney's office, when we first did the request, wasn't sure where we should go. So our request went through the, I went to the Attorney General's office. So someone in their office looked at our request and analyzed it and came back and said, no, you should go to the state's attorney's office. So we said, okay. So we went there and didn't hear, and it was wrong time. It was during the time of an election, and really you shouldn't ask nobody to come out to sit down and look at, says, where's all your people should be going, but we did, but then y'all came back and we do thank you. And you're here tonight. So I'm not sure what is happening to Larry. And
I'm not sure either. I've emailed him and I've texted him, so I'm trying. Should we just go ahead with Miss Ward first, Betty?
right, okay, yeah. So Ms. Ward, so the unit that you in, could you kind of give us an overview of what that unit entails?
Sure. So in the unit that I supervise, we're called felony review, and we are basically the intake unit of, if you will, of the cases as they come into the state's attorney's office. So my unit was created to in the 1970s, very, very early in the 1970s, maybe late 60s, when they were creating a screening or a reviewing process to make sure that a case was in the proper or best position that it could be in to be successful in court. And so my unit is comprised of 6 teams of assistant state's attorneys. Each team has approximately 7 state's attorneys or so on the team. We work 24 hours a day. We never close. We work 7 days a week, including holidays. And we respond or answer to requests of 120 law enforcement agencies throughout the county. So we serve the entire county. We don't just serve the city or a particular suburb. And we serve all our communities throughout the county, and we are countywide. So you can imagine it's quite busy. What we do is, if a crime is committed in Cook County and law enforcement believes, number one, that the crime is a felony, right? It's not a misdemeanor, but it's a felony crime. And number two, that it has enough evidence that they want to seek charges against somebody for that crime, they will contact our unit. When they do contact our unit, what kind of we do is we respond. And so we take a look at the case, and that involves a lot of different things. We interview victims, we interview witnesses, we speak to offenders if they're willing to speak to us. and we look at all the evidence that's presented to us, physical, video, whatever, digital, whatever it could be, that's presented us by law enforcement. And then ultimately we would make a determination as to whether or not a case would be able to be charged. So one of the things, like, I said, is we look at the evidence that's presented to us. We are not an investigative unit. We don't investigate. We don't have investigative powers. We don't have arrest powers. We cannot order people to turn things over to us, or we don't go out and search for witnesses and all that. We rely on the police to do that work and to then work collaboratively with them to see if the case is in that posture where we are able to make a charging decision. And so when we're looking at a case and we're thinking about it in that kind of idea of, whether or not we can make a charging decision, I mean, first and foremost, obviously, the biggest important thing is we want to make sure we have the right person, right? That the right person is responsible. That's what law enforcement wants. That's what we want. And that's the one thing that that's very, very important that we want to do. And we want to make sure, another thing that we have to make sure is that it meets the law. And the law sets out different, what we call elements, or different factors that have to be met. And each one has to be met in order for a crime to be charged. We want to look at we have to have facts on our side, right? So if we don't have the facts, meaning we don't have witnesses that cooperate, or we don't have that kind of thing to show that we meet these elements that would then show that the law has been broken, that would be a problem. So we need the facts, and we need evidence on our side, meaning we need physical evidence, we need witnesses, we need, possibly physical, video, whatever evidence that we have. And then as prosecutors, there's different rules that apply to us. And one of those things that apply to us is we have an ethical obligation, or we have an obligation to make sure that when we are bringing cases into court, that we believe that we are going to have a successful prosecution, right? And that we are meeting at least our ethical standard of review, and that the law is being met, and that the law is being followed, and that all these other factors are being followed, and that, and then we are looking at justice, right? And also incorporating the mission, vision, and values of our office, which include, or basically is seeking justice, and includes trying to make the communities safer and healthier and better places to be in. And so we take all of that. And, when we're looking at all these things, we're taking all of that into account. It's not just one thing, it's all of that. And when we take all of that into account, it's not just a very, very simple case, right? Like, that's a lot. And we have to look at all of that before we make a decision. And so when we make that decision, we want to make sure that we're making the right decision, right? For the case, for the victims, for the community, to make sure that we are getting justice for everybody involved, and it's the right decision as well. So there's a couple different decisions we make when we make our decisions in felony review. One of those decisions is we can say we're declining to prosecute at this time, that there is something in those things where, that we just talked about, there's missing. We can't meet the law. There's facts missing that doesn't give us we can't meet our standard. We can't get into the position that we need to be to prove that this person broke the law, or that the law was broken. That doesn't mean the case is closed. We are always willing to look when new evidence comes in. People come forward sometimes later for different various reasons, or are willing to cooperate when they're not willing to cooperate at at different times, or, things change. So although we decline to prosecute, that is based on the evidence that's presented to us. Meaning, if there's other evidence presented to us, we may change that decision. We could ask them to continue their investigation, meaning that we would give some suggestions to them that we believe that would be a pathway where if they were willing to do so, a case could maybe make it into the to meeting those standards and would be able to make it into the criminal justice system and get it into a posture where it could be charged. So in that respect, we can only make suggestions because we are not an investigative, but we know the court, right? Like we go to court every day. We know what is necessary. We know what is needed. And so we can make those suggestions to law enforcement, but it's up to law enforcement to choose to follow those and to do those investigations and then to call us back. And then we continue on with the case. And then we can approve the case, right? And then the case comes into the justice system, you know, and starts going through the court process at that point. It's very important that we do what we do and we follow these guidelines, because what you don't want is you don't want someone, number one, wrongfully charged, right? And you don't want to charge a case that should not be charged, because in the end, what that really does is just re-victimize the victims in the communities. Because in, you know, a couple of weeks or a month or a year from there, the case may be getting dismissed, or it gets a not guilty, or it falls apart. And you knew it. If you knew that was happening ahead of time, you have an ethical obligation not to do so. Right? You know, we should not be victimizing victims over and over again when we know that they're, you know, that these don't meet those standards. So we're very careful with that, but with the open mind that if additional evidence does come forward, we would consider it at all times. I know you had some questions about kind of what happens once a case comes into court, and I can kind of briefly, that is not my area. Obviously, my unit kind of does this. I can briefly go through, you know, obviously I've been through these units. I can kind of briefly talk to you about it. Once they leave, once my unit charges, would you like me to kind of brush upon that?
Yes, because, well, what you just said and went through is very informative, but kind of we was looking for, okay, say, God forbid, but say I get arrested by the police.
Okay.
And then I go to jail, and then I go over to the court, you know, and I have to wait to get, what is it? Go to the judge to find out, do I stay there? Can I go home? Do I have to come back to a trial? So.
Okay. In general, you know, I could talk a little bit in general on this. So once we charge, so if you're actually charged with a felony charge from my unit, or, you know, in that respect, your next stop is most likely going to be a bond court. Okay. And that's really your first appearance before a judge. Usually it's going to be like the next time a judge is available, which would be like business hours, right? Like whether it's the weekend or a weekday, it's not going to be in the middle of the night. It's going to be, you know, it's going to be business hours in general. When you appear before that judge is just merely setting bond. Now, what that judge wants to hear is from the state, what they want to hear is anything in aggravation. So what that means, it's a term we use, but what that means is we're presenting the facts of the case that, you know, we, you know, in the best light for the case. We're presenting the criminal history of that person that's charged. There might be, if it's a domestic case, we might present like all the different domestic arrests or history that they've had of creating abuse on someone and things like that would be aggravating to keep that person. Maybe they've forfeited bond, they've been given bond in the past, but then they forfeited, meaning that they skipped their court dates and didn't appear. And so we would mention those, and we would try and, our, to get a fair bond, or at least a significant bond to possibly hold the person if we felt that was a fair way to do it. If we felt that it was a property crime and maybe not, then obviously that's a fairer bond. And so it depends on what you're charged with. But like, let's say you're charged with a carjacking or a murder, we're going to do a little more aggravation than if it was a retail theft or a burglary or something, right? So those are things that have to be considered by the judge. But in reality, the judge makes ultimately that decision, at least as it, as it is now. And I know there's some changes that might be coming through, which I am not privy to those meetings and all that knowledge, but you're gonna then get your choice, right? So like if you're charged, you're gonna talk to your defense attorney and you're gonna tell them everything, like why I should be on electronic monitoring, or why I'm not a flight risk, or why this isn't aggravating, or why, I've, school and family and ties to the community and different things like that, that would show in what they call mitigation, and that they would, consider that as well. And the judge has to weigh that, and they have to weigh the charge. What's that charge? Is it violent? Is it not? Do they, they weigh the aggravation, they weigh the mitigation, they try to see, we don't ask for an amount, or we don't generally, unless it's a very, very violent crime. There are certain crimes where we can ask for a discretionary no bail or a mandatory no bail currently. Those would be for murder, right? Those are for attempt murder. Those are for carjackings. Those are for things like that. Other than that, everybody just wants a reasonable bond, right? We want to make sure it's reasonable to hold this person so responsible to come to court. And that's what the purpose of bond is to make sure they show up to court. The defense is going to obviously argue that they want and put on their best case, and the judge will make that decision. Once that decision's made, the person could be on electronic home monitoring. They could be released on an I bond, which just means that they're on their own recognizance, almost like they're just released. They don't have to post money or anything like that. Or what we call a D bond, where they have to post a 10% of the amount of the bond set. So, $1,000 would be 100 or whatever. So before they get out. So those are like the different types of bonds that could be set. So it's an I bond, a D bond. You can always put a condition of electronic home monitoring, even with a D bond or an I bond, or you could just give someone electronic monitoring. They could do either, I guess. But that's kind of the judge. So you might go home, you might not, depending on how things go. If you can post the money, or someone can post that for you, I would say that it probably takes a little while, but to get you released, I'm not sure the timing of that. I don't know. I don't work in that. I don't work in the jail, so I don't know. Once you do that, whether you're in custody or not, you're going to go to the next stage hearing, which is going to be a couple weeks from there. And you're going to go to a preliminary, or a very short time after the bond hearing, you're going to go to a preliminary hearing stage. And that is basically a hearing, or where either a judge or a grand jury is going to make a decision if there's probable cause enough that the case is basically strong enough to remain in the system, is basically the decision they're making. And they do that based on testimony. Those are the two ways a case will ultimately make it into a felony courtroom. So some people go to a preliminary hearing, and there's different preliminary hearing courtrooms. There's one in Skokie, and there's some on the South Side. Branch 38 is over at 111th and Wentworth. And there's different, so there are different ones around the city. There's numerous preliminary hearing courtrooms. And then there's the homicide and sex crimes preliminary hearing room that also handles juvenile auto transfers, that is here at 26th Street. So you're going to get assigned to one of these rooms and you're going to be required to appear, and there's going to be a hearing of some sort, or the state can elect to indict you with the grand jury. Now, that's a secret process. We announce that we're going to indict, we'll just get a continuance date, we go and indict it, and then your next court date, we announce the indictment, because you're not allowed in front of the grand jury if you're an offender. If it's a preliminary hearing, you're present, and it's actually testimony and almost like a mini, very, very mini trial in front of the judge. Either way, if there's a finding of probable cause, you're then going to go into a courtroom. So whether it's, a suburban courtroom, so depending on where the crime occurred, it could go to Skokie, Rolling Meadows, Maywood, Bridgeview, Markham, 26th in California. And once you get into a courtroom, you could still be in custody. Each place you go, you can ask for bond to be reviewed. You have the right to have bond reviewed at any time. And with the new law, it's my understanding that's going to even be a mandatory review constantly. But again, I'm not an expert on that new law right now. That's something that other people who are dealing in that, who work in that unit, are dealing with. But you're entitled to a bond review anytime. And you could always, if you are in custody, ask for one if you're an offender, and get one, right? And bond can change. But once you get into your first court date, if there's a finding of probable cause, you're going to get arraigned. So you have to enter a plea of not guilty or guilty. And you have to, and then the discovery stage starts. What that means is the state, we're going to order all the papers and all the stuff and all the information and videos and all from all the people that touched the case. And we're going to tender it to the defense. And then they are going to order everything. Once we finish and complete it, they have the opportunity to order anything they want. And then we go to the trial stage. Now, in between that, there's a lot of things that can happen. Like pleas, motions can be filed. And if we lose them, sometimes we can't meet our burden anymore and we have to dismiss the case. Or we can do conferences in front of a judge. And the judge can make an offer. We can make an offer as the state, or we could go to trial. And at that point, then the defendant, the offender, would have the choice, and he only has the choice whether he wants a bench or a jury trial. He has, because it's his freedom that's at risk. It's his decision whether he wants a judge to decide it or a jury to decide what's going to happen in the case. So I don't know if that answers some of the questions you had, but it's kind of just a big, broad overview.
Now, it answered a lot. Before we move on, and I can check to see if any of the participants has a question. Larry has joined us by phone. Larry, can you unmute yourself? Can you unmute him, or does he have to unmute?
He has to unmute, but I just asked him to unmute electronically.
Okay.
Here he
Okay.
is.
Can you hear me now?
Yes, we
Yes.
can. Hi, Larry. And
Okay.
I do
Hi.
apologize for the difficult that you had for getting
Look.
on. It's my fault.
Well, don't worry about it. I'm in now, so, and that's all that counts.
Yes.
I got a chance to listen to a part of the presentation, and I appreciate it. It was a good presentation.
Thank you.
Okay. Now, did you have any questions or anything that you want to add? Because I kind of wanted you here because you have been to court with individuals and stuff. So some of the things that we're asking, I might not ask, is kind of crucial, because she said something that with the person they go to court, and then I guess their office decide what happened to them after the police arrest them. So when the police arrest them, they give them a ticket or summons that has on it is what they are charged for, correct? Yes.
So only,
Yeah.
so
Mhm.
only with felony cases though, that's different. So no tickets, no misdemeanors. It's not everybody that's arrested. It's only a felony charge. So it's a little narrower field than that we deal with.
Oh, okay. I see Elliot has his hand up.
Yeah, I have a quick question. Where does the access to defense counsel come in? I mean, you mentioned of a person appearing in court with a lawyer. Well, how does that happen? Suppose the person who's been detained or even charged doesn't have access to a lawyer, through personal connections, whatever. How does that work?
Sure. So a couple ways. I'm just going to kind of broaden this a little bit. When the person is arrested and the police read them their Miranda rights, they have the right to invoke the right to an attorney. One of those rights also says if you can't afford an attorney, one would be appointed to you for free. And so basically at that point, the police stop talking to him, and then he will go to before either if we don't charge, if it's a felony only. If it's a felony and my unit decides not to charge, he will be released. And that's not an issue, right? If he's charged, just like the other offenders that are charged, at the earliest time possible, which would be the very next morning, usually, he will be brought before a judge, and there's public defenders that are there. Now, there are also a group of public defenders that are on call for like murder cases or more, those kind of cases, and also for juvenile offenders that come to the districts, to the areas and respond as well. And the police have their numbers and will call sometimes, we'll call them as well.
So-
Can I chime in on that?
Go ahead.
She's right in that typically you don't get to see a lawyer until your first court date. But by then, it is too late. And so you have the right to request an attorney while you are in the police station. And there should be, it should be posted that you have a number 2. It used to be FDLA, but now it's the Cook County Public Defender's Office. And someone from that office will come down to the station in order to be with you while you're being investigated by the police officers themselves. That is not common knowledge, and so a lot of people don't take advantage of it. But that is the first opportunity for you to get a lawyer, and that is you have to ask for him. You have to ask for the lawyer yourself. And maybe the police will, grant you that right. Maybe they won't. That's been something of an issue in this city, in fact, throughout the country for a long time. But if you ask for a lawyer, you're supposed to be able to get it, even in the police station, before you go to the bond hearing, to the probable cause hearing, to any of that. You should have you can get a lawyer even before then.
And there are public defenders that routinely come out to the areas. I do know that.
Yeah, right. And that's new within the last few years. But yes, they are available.
So may I ask a question, Larry? This is Elizabeth. So,
Yeah.
So if I were arrested, I'm in a police station, and I say I would like to call a lawyer. and I don't have the number of a lawyer. I mean, I can imagine that I might be allowed to make a phone call, but if I don't have the number of a lawyer, are you saying that I have the right to ask for a public defender when I'm in the police station?
Yes, you have the right
Okay.
to do that.
Thank you.
And their sign, they are, and Larry's right, there are signs posted.
Well,
I'm sorry, go ahead, Larry.
let me, the signs are posted, but, and this is, when I was going to police stations, doing these kinds of station calls, often the sign is in the lockup, and it should be in the interrogation room, but it rarely is. At least that was my experience. So that by the time you see the sign, anything that is harmful to you may have already been recorded and in a position to be used against you. But technically, yeah, you should be able to call a lawyer at any time. I just wanted to add that a little bit.
Okay, yeah. With that, we do have that little card that is posted. I'm not sure what wall it's on at the Evanston Police Department, but I do have a copy of it, and we put it on our Facebook page as to, this is your right, this is the number to call and stuff. And we owe that due to the courteous of our, let's see, which one was she? Our former police chief, Aretha Barnes, gave us that, because that was something we had been talking about in meetings with the police department. So do anyone else have a question? What about you, Patrick? You're a young person that goes out at night and might run into the policeman. We're not saying you're doing anything wrong, but do you have any questions?
No, I actually didn't have any questions, but I do appreciate the information. It was good information. But no, I did not have any questions.
Okay, yeah.
Let me chime in on that, just because it's an opportunity to educate at least one person. If you're being arrested, do not resist, but also don't talk. Don't try to explain your way out of it, because by trying to explain your way out of it, you might be giving the police information that can be used against you. And when you're being interrogated, tell them, I will not answer any questions without my attorney being present. And use that phrase, that statement for any question they ask you. If they find that you're not being forthcoming with information, they'll get a lawyer for you, or not. They might just let you go. I don't know what they're going to do. I mean, this is the police. They can do whatever they want to do. Investigating crimes is what they do, and people can't just second guess what they do. They do what they do. But to protect yourself, always tell them that you will not answer any questions without your lawyer being present, and stick with it. And you might have to stick with that for a couple of days. That's all I want to add on that.
Okay, yeah, I will, what was it? I don't forgot the date. In November the 17th, when we had our educational event for the month that we always have is the 10 rules for dealing with the police department. And in that event, because we looked at this video that it was put together by the ACLU, and they talk about the 10 rules for dealing with the policeman. And one of the things that was stressed in the video and the attorney stressed was that you always ask for your lawyer. Don't say anything till you get the lawyer there and everything. And to go back to one of Elizabeth's question, because it came up, and the idiot box had it, while this person made 3 calls looking for a lawyer. So it made me think, do they, do you have more than one chance to try to reach your lawyer? Because like she could have called home and asked her husband, I've been arrested by the police, so you find me a lawyer. And then she could call herself again and ask, to reach the public defender. Or do they just get one call to get a lawyer?
For me,
Uh-huh.
so there's a new law in place where where someone who's in custody, it's mandatory that they get at least 3 calls within a certain amount of time of being in custody. So you'll see, a lot that they'll give them their cell phones, or at least show them their cell phones so they can look up numbers, or they'll, let them use it to look up a number, to use a department cell phone to call whoever it is. But yes, it's mandatory they get 3 and then that kind of is my understanding, at least, that, and that might just be a CPD rule, but I know, like, we deal a lot with Chicago Police Department, and so, but they get 3 calls, and so when someone's in custody, I know, I'm aware of that. I know my detectives are aware of that at some point they're going to be able to make at least 3, these 3 calls. But if you ask for a lawyer, they are supposed, they're supposed to honor that. And yes, you could change, and someone could send a lawyer, and a lawyer and a lawyer shows up, they have to allow access for that lawyer to that person.
Okay.
By law, if a lawyer shows up for you, if your family calls a lawyer because they know you're at the police station, and that lawyer shows up at the police department where you're at, they have to let you in to see, they say, I'm here to see my client. They cannot tell you no if you're a lawyer for that person. You say you represent them.
Oh, I didn't know that. That's something new I learned. The other thing too, from the 10 rules for to know your rights, the attorney that we had was with and we asked him a few questions about the new criminal reform law that was passed in July of 2021, with a lot of the things that's in that bill taking effect the first of the year. And one of them was about them with the phone numbers that, they have to let you keep your phone, cell phone. And so he said that, and he might have said to use it to look up lawyers, or to look up number that you need to call someone to get your lawyer, because you could have a family lawyer. I don't remember, but he mentioned that that was part of that reform bill that was in there.
I'm not aware of that part. I think they have to allow you access to look up numbers and things like that. I'm not aware of any law that, and I don't know that whole bill inside and out, so, I'm just caveat that, but that would allow them to hold on to their phone while they're in custody. There's so many things that could happen. There's even could potentially be safety issues. They don't even allow you your shoelaces, right? Like things like that. Like there's many reasons for that. They could be destroying evidence in the case, right? If it's on their cell phone, they could be deleting it and things like that. So that generally, I don't know. But as far as my knowledge of that area, they have to be given access to look up numbers. They have to be given 3 calls. As far as being allowed to keep their cell phone in lockup with them at all times, that I've never heard of. But I haven't read that act inside and out either. I deal with what with charging. And so the things in there that affected me were the electronic home monitoring hours that you can be violating it and things like that, that obviously affect charging ability.
Okay. Yes, Larry, you have a question, something to.
No, I was just going to add a teeny bit to that. Actually, just to mention, I think that she's absolutely right. They will not let you have a phone back there for the reasons that she mentioned. And the I don't know that bill, that new reform bill either, because I don't deal in this area anymore. Primarily, I'm doing in civil, a civil practice now. But when I was there, they allowed no phones at all, and even an attorney cannot make a phone call back there because by state law at that time anyway, it was a felony even for an attorney to make a phone call. So you want to, if they allow you to look to have your phone to look up numbers, that is, I agree, within their purview to allow you to do. But to have your phone with you while you're in the lockup, that is highly unlikely, and I'd be really surprised if that happened at all. That's all I have to say on that.
Okay. Steve, do you happen to have a question? Or Doreen? Can you see my water? No.
So Steve indicated he does not, I think.
I guess not.
And Doreen? Doreen,
no
here's
question.
Doreen.
Okay.
No question. Thank you. Very
I
good
have a
presentation.
question.
Okay.
Another one. So am I understanding, Ms. Ward, that I'm hearing that, okay, so a person can ask to call a lawyer, a person can ask for a public defender in the police station. And Larry, you were saying you may or may not be given that. But Ms. Ward, are you saying the police have to give you that? Because yeah.
What I'm saying is, if you're requesting a lawyer has to be made available to you at the earliest accessible convenience. Now, whether that's at the station, or as Larry was saying, realistically, with these public defenders that are now available, or it used to be first thing, when you get brought before a judge in court, that's up to, that's how they do it. That is and just so you guys know, we don't get involved in that. We're not there. Right? Like with that, once somebody asks for a lawyer, we don't have any contact with them, our office. We don't consider, generally, that's kind of like that person is not available to us, right? Are some, I know personally that there is, because I've had detectives say, the public defender was here, right? So I know that they go there from just cases where I've talked to detectives and they told me, like, the public defender was here for him, things like that. The public defender is not on call for somebody, right? As far as personally, right? Like, they're not a hired attorney, so somebody had to call them to get them there. I'm assuming it was the police do have their number. There is a protocol in place through the police department to get them there. And so then that's kind of, I think some of these questions are for the police as far as for them, like what their procedures are.
Mhm. Okay, thank you, because I was not remembering from that Know Your Rights video that you were talking about, Ms. Esther, that it was said that you can ask for certain things or say certain things during the encounter with the police. I know it's not this program, but I was just thinking it might be similar, and you may not be granted them, but it's important to ask for them. I'm trying to remember the specific example, because later it could be helpful to you if you did that. So even if your request is not granted at the time that you have that first encounter with the police, there's some kind of wise things to do. And it sounds like asking for the lawyers would definitely be one of those. Larry, do you have a sense of that?
Yes. When I was doing these station visits, we would have we would apprise the police, the person sitting at the desk, that this person is represented by counsel, and present a copy to the police department stating that this person is represented by counsel. And if they will sign it, we'll have them sign that document before we give it to them. But because if a person is asking for an attorney while he's in the police station, and the police do not give him access to an attorney, then it becomes a contest of words. The person can say at a later date, I asked for a lawyer, and the police can say, no, he did not ask for a lawyer. So when we make station visits, we document the fact that we've been there, and so that they can't say at some later time, no, no attorney showed up. Now, I suppose that the public defenders are doing that kind of documentation as well. I don't know that, because I haven't kept my finger on that pulse. But that is the kind of thing that I'd be really surprised if they were not doing, because they're in the best position to handle this person's case. And if they visit them in the station, in all likelihood, somebody at least familiar to them will be taking up that case at a later time. And so they want to keep a paper trail from the time they walk into the police station all the way through the case, so that they can be as effective as they can in representing that individual.
And excuse me, Larry, but and also the police do document, or should be documenting it as well. I've seen it documented in cases that I've done.
Yeah.
And they should be documenting that as well, that attorney showed up. Usually they take a photograph, a Xerox copy of their business card, or they write it on a note and insert it in their file to make sure that the number and the name of the attorney and the time they showed up is all documented. And if they give access, when and what time that was done, they should be, is what they should be doing.
Right, and often, and typically they do. I mean, it is usually they follow the rules.
Yeah.
But sometimes they don't.
Did anyone else have a question?
I see,
during-
Doreen, that you have something to ask.
Oh, no, thank you.
Okay.
I wonder, Tricia or Darlene? I don't think we've asked you yet if you had anything you wanted to say or ask. Okay.
Okay, well, it is, I don't see a time. Have to look, okay, it
It's
is
8:10.
8:10. And unless someone have a question of something, we will be ending this session of our educational event where we hope that the information that was given was helpful to the participant and hopefully the community.